I will just put on my camera for a while so that you can all see me. This is Hanonisha Hendricks. I'm with Legal Aid South Africa. I will be the moderator for today, but Karen Renser of Mosaic will be the presenter for today. And Karen will talk to us about the amendments to the Domestic Violence Act in a simplified way, explain what the differences are that the Act brought in, the additional interventions that is made available now. So just a little bit more about Karen. Karen is a gender justice and gender-based violence advocacy specialist. She specializes in policy and research. She's based in Cape Town, and she is the advocacy consultant for Mosaic Training Service and Healing Center. So Mosaic is an organization that focuses on empowering women and girl survivors of violence, domestic violence and abuse, by creating an enabling environment for them and supporting them through their healing process and ensuring that they become positive and active drivers of change in their own lives. So that is what Mosaic, the organization, does. Karen is a registered social worker, and she holds a master's degree in social policy and management from the University of Cape Town, South Africa. And Karen has worked in this area of gender-based violence for more than 10 years. Her key interest and expertise is domestic violence, particularly intimate partner violence. She is known for her forward-thinking and collaborative approach to systems strengthening and policy issues to increase access to justice and promote prevention of gender-based violence. So she has coordinated national and collaborative campaigns, including the National Stop Gender Violence campaign, the campaign that saw the initiation for the call of the National Strategic Plan on Gender-Based Violence at its inception back in 2014. Karen is an active participant in the National Strategic Plan Gender-Based Violence Pillar 3, and she represents Mosaic in the Pillar 3 working group focused on the training component of the state of readiness to implement the GBV amendment bill. So the GB, one of the amendment bills being the Domestic Violence Amendment Bill, which we are going to focus on today. She believes that gender equality and with it the eradication of gender-based violence is attainable if approached through meaningful multi-sectoral collaboration at local, regional, and global level. And so Karen will talk to us today and just explain what the Domestic Violence Amendment Bill will bring and seek to make available to survivors. Luwando, are we ready to flight the slides?
Not yet, ma'am. I haven't received the presentation. However, when I do, I will just flight it.
All right, well, hello everybody. I am Karen, as I was introduced by Hananisha. And Hananisha, thank you so much for that fantastic introduction. And thank you also to the Department of Justice and Constitutional Development, as well as the Pillar 3 Working Group on Training for putting together this set of webinars. Apologies again for the multiple technology challenges that we're having this morning, but I think we can go ahead. Just as a caveat up front, I'm going to try and position this. I am also having load shedding at the moment, but at least my connection is good, and hopefully the lighting stays with the various contraptions I've got up so that I don't look like I'm in a dark room. So today, as Hananisha said, I am going to be presenting on the Domestic Violence Amendment Act. And the purpose of today's session is really to unpack the amendments in a very easy to understand and simple way. And this is really aimed at those of us that maybe haven't quite engaged very much with the amendments as yet. As we know, the Domestic Violence Amendment Act was assented in January of this year, and the regulations were published for comment just a few weeks ago. And we heard last week in the webinars around the regulations and what those mean. So it's still relatively new. So let's dive in and see how we can unpack this. While we're waiting for the presentation to be flighted, what we will just to give a few sort of housekeeping. I'm not sure what Hananisha went through before I joined. Londo, I see your hand is up.
Yeah, so ma'am, I haven't really received the email, so I'm not sure what's really happening.
Okay. I'm not going to be able to flight it from my phone. So I will send it to Hananisha as well, just as a backup. It is quite a large file, so that could be why it's taking a little while to come through. But I'll send it to Hananisha as well.
I'm just confirming, Karen, I've received it and I'll try to flight it.
Oh, great. Thank you so much, Hananisha. I appreciate that. All right, there we go. Can you just go one slide back, please, Hananisha? Okay. So just a few housekeeping. If you have any questions, please note them down either in the comments or just keep them with you. There will be time for us to talk through some of those things after the presentation. And then there will be a PDF version of this presentation provided to the Secretariat. So you will receive copies. So you don't have to try and jot things down or take screenshots. You will receive a copy of the presentation. So next slide, please, Hananisha. So just before we begin, a little bit about Mosaic. Hananisha's already introduced Mosaic as a community-based nonprofit organization that really has the vision of something strange is going on there, which has the vision of ending violence against women in all its forms in our society. And it does this by working to prevent and respond to domestic violence by providing a holistic set of services that empower women to claim their rights. I'm sure the presentation will pop up as soon as it can. There we go. But if we could just change the mode of presentation so it doesn't show the next slide, please, Hananisha. So let's not waste any more time. So let's look at the pillars. So Mosaic really tries to work towards prevention, but also wants to work in a very supportive and collaborative way. So understanding that no one organization can end domestic violence or sexual violence. So we work in a collaborative way with departments and within government, but also other organizations to achieve our vision of ending violence in all its forms. Now, Mosaic has close to 30 years of experience in working within the context of gender-based violence in South Africa and offers domestic violence services in partnership with the Department of Justice and Constitutional Development and the Department of Social Development within magistrates' courts in the Western Cape, KwaZulu-Natal, and Gauteng, and also provides psychosocial and HIV support services as a first responder in TCCs in the Western Cape in partnership with the NPA and Department of Social Development. We've also been, through our advocacy and policy work, very involved in the legislative drafting process and also in advocating and lobbying for changes to legislation that is responsive to the needs of victims and survivors of domestic and sexual violence. I'm not sure what's happening, but if we come back, we're on slide 3. So if we look at the Domestic Violence Act, the purpose of the Domestic Violence Act has not changed. The purpose remains to afford the victims of domestic violence the maximum protection from domestic violence that the law can provide, and to introduce measures which seek to ensure that the relevant organs of state give full effect to the provisions of this act, and thereby to convey that the state is committed to the elimination of domestic violence. Now, that's a very long statement, but that is what we see in the preface to the Domestic Violence Act of 1998, which remains in place with the amendments. Oh, thank you, Anisha. So we're on slide 4 now. So what is the Domestic Violence Amendment Act? Well, it helps sometimes to just look back into what the history of the law is or has been that has informed the protection of those who experience domestic violence. We're just on the next slide, Hananisha. So the legislation for domestic violence started with the Prevention of Family Violence Act in 1993. Now, this act was quite narrow in its definition of domestic violence and required, and this is where the language around interdicts and peace letters and those types of things that we still hear sometimes, that's where that language came from. In 1998, the Domestic Violence Act was assented, and this was seen as an incredibly progressive piece of legislation, not only in South Africa, but across the world in response to domestic violence. And this has, for the last 23 years, has governed and led how the country responds to domestic violence. And now we see that we have the Domestic Violence Amendment Act. And what that means is there are really just amendments made to that, what we call principal legislation. So what does these amendments aim to do? Well, within the Domestic Violence Act, there have been practical gaps and challenges that victims have experienced in accessing justice. And the amendments to this act aim to change that. It also aims to make sure that the law is more accessible and protects victims and guarantees them the service that they require. And if you don't mind, I'm just going to turn my camera off so that I can just see the slides, if that's okay with everyone. And then it just in total enhances the application of the Domestic Violence Act by the various actors. So the next slide, please. So if we're looking at the Domestic Violence Amendment Act and the Act itself and what it covers, we'll see that there aren't really too many changes in what it covers. We still look at the reporting of domestic violence or intimate partner violence, and we look at the process of applying for a protection order, the issuing of those orders, as well as the enforcing of the protection order. Now, how does this come into being? We often hear about it's great legislation is black and white on a piece of paper, and rightfully so. So we need things that are going to operationalize or bring the legislation to life. Now, last week, there were 2 sessions run that focused on the published regulations. Now, these regulations really put out and emphasize what is put in the Act of how the Act needs to be implemented. And that is put out by the Department of Justice and Constitutional Development as the keepers of its law. And then it is up to the departments to issue directives and national instructions. And this would then speak to how those departments are going to implement their mandates under this law. Now, the previous act, or the Domestic Violence Act we currently have, was focused on the traditional justice sector. So Department of Justice and Constitutional Development, SAPS, and the National Prosecuting Authority, and the magistracy. This is now expanded, and it's expanded to include the Department of Health, Social Development, Basic Education, Higher Education and Training, as well as Communication and Digital Technologies. Now, we'll see later on in the presentation why it is imperative that these departments are included. So let's go over to the next slide, please, Hananisha. So when we're talking about domestic violence, we want to fully understand what a domestic relationship is. Now, please, just a caveat, as I said at the beginning of this presentation, this really is aimed at those that haven't really engaged and for us with the legislation, but for us to also understand, walk away from this presentation understanding who this law is applicable to. So what is a domestic relationship? Well, the Act defines a domestic relationship as a relationship between the abused person and the abuser in any of the following ways. Where the persons are married or were married, including marriage according to any law, custom, or religion. And that's important, is that it's not only a marriage that is a legal marriage, but any form of marriage. The abused person either lives or have lived together in a relationship. They are parents of a child or are persons who had a parental responsibility for that child. So they may have been guardians. Or the abused person is or were in a close relationship with the abuser. But what is a close relationship? What do we mean by that? Well, a close relationship means a relationship between the abused person and any other person, taking the following into account: the degree of trust between the persons, the level of each person's dependence on and commitment to the other person, the length of time the relationship existed, the frequency of contact between the persons, or the degree of intimacy between those persons. Now, what does that mean? What are some of the examples of these close relationships? Well, it might be a friend where there is frequent contact, a neighbor who is also a good friend, or the person's romantic partner. Now, when we, the next slide, please. Now, when we talk about a domestic relationship, we often speak about blood relations or family relations. So let's look at those. The Act speaks to family members related by consanguinity, affinity, or adoption. Now, what do these words actually mean? Consanguinity means people who share blood relationships with each other. So those are blood relations. Mother, father, brother, sister, son, grandparents, grandchildren, nieces, aunts, uncles. So anything where there is a blood relation. Now, a relationship by or family by affinity means relationships because of marriage. So that could be a mother-in-law, husband, wife, sister-in-laws, anything that is because of marriage. And finally, adoption would be where a relationship exists because somebody or a person was adopted into a family. So it may be an adoptive child or an adoptive parent, or people who are in a relationship providing care to an adopted child. So hopefully that clarifies a little bit of that language. Now, the next slide, please, Hananisha. Now, when we talk about a domestic relationship, there is this concept about actual or perceived romantic, intimate, or sexual relationships. Now, often when we talk intimate partner violence, these are the relationships we speak of. We speak of where an abused person is or was in an engaged, dating, or a customary relationship, And we speak about the actual relationship. So this is where I'm in a relationship with someone and we both agree we are in a relationship, whether that be just a romantic, an intimate, a sexual relationship of any duration. But we both agree that we are in a relationship together. Then there's this concept of a perceived relationship. Now, this is when one person thinks they are in a relationship with another, but they are not. So there may be I'm in a I see someone quite regularly, and in my mind, I am in a romantic relationship with this person. But there's never been a conversation about whether we are actually in this romantic relationship. So, quite a confusing concept, but it is one that the amendments make provision for. So, now that we understand a domestic relationship, let's look at some of the key changes that the Amendments Act puts forward. So we can go to, actually you can skip, yes, just one more slide. We can go straight over to what domestic violence actually is. Now, domestic violence, according to the Amendment Act, is we see quite a bit of the same as what was in the Domestic Violence Act, except for a couple of changes. So what's new? So in the Act, we see a very clearly defined definition for spiritual abuse. And here the Act speaks to spiritual abuse as when someone advocates hatred against the complainant because of their religious or spiritual beliefs. It also speaks to preventing the complainant from exercising their constitutional right to freedom of conscious religion, thought, belief, and opinion, as well as manipulating the complainant's religious or spiritual convictions and beliefs to justify or rationalize abusing the complainant. So let's look at some examples of this. So if we talk about advocating hatred, this could be based on you're in a domestic relationship with someone and you don't agree with their beliefs, their spiritual beliefs, and you then start inciting violence against them, either by yourself or using other people because of their religious beliefs. You could also prevent the complainant from reading their religious texts or attending their religious service, and that could also be a form of spiritual abuse. And finally, using the religious texts or beliefs as a way to say, well, the religious texts say that I may abuse you in this way. So that's spiritual abuse. The next addition is the exposing of a child to domestic violence. And this brings this amendment in line with the Children's Act as amended. So not only acts of violence towards a child, but just a child being exposed to domestic violence. There's also related person abuse, and this speaks to people who are possibly supporting a victim of domestic violence, whether that be a professional person or a functionary or someone close to that person, where the violence then gets directed at that related person. And finally, elder abuse. This has been defined as a separate category of domestic violence and really again aligns the Amendment Act with existing legislation, and in this case, the Older Persons Act of 2006. And one other change is you will see that stalking is no longer stipulated as a separate form of domestic violence. Now, this is something that was quite hotly contested through the legislation process, drafting process, but to bring the Amendment Act in line with other pieces of legislation, stalking is included, but forms part of harassment, and this brings it in line with the Protection from Harassment Act. So these are the changes to the definition, or at least the expansion, to the definitions of domestic violence. And again, remembering the purpose of the amendments is to make the law as accessible as possible. So here we see the amendments have really tried to clarify what is meant by these various forms of violence. Next slide, please, Hananisha. Now, what the Amendment Act makes quite clear is that there is now a duty to report domestic violence. But the Act makes it compulsory only for specific people to report domestic violence that is enacted against certain groups of persons. Now, as was mentioned last week, there were a lot of questions last week around the regulations and why reporting or mandatory reporting is limited to specific groups of people. And one of the reasons for this was around the agency of a person to decide whether to report violence that's perpetrated against them. But also it was felt by a lot of civil society organizations is that if someone discloses their abuse, an adult person discloses their abuse to a friend or their child is exposed to violence and they themselves do not report, they can be criminalized, but it also could reduce help-seeking behavior of persons who are experiencing violence. But what we see now in the Amendment Act is the duty to report for specific groups. Now, who are these specific groups? The specific groups are a child, a person with a disability, or an older person. And those that are required to report these acts of domestic violence is any adult person. So it doesn't matter who you are. It is just any adult person. And then functionaries. So functionary is a term, a basket term for medical practitioners, healthcare personnel, social workers, any official employed in a public health establishment, an educator or a caregiver, or any other person that the minister may designate. Now, when we look at the list of these functionaries, we can see why it was so important for the expansion of the relevant departments that are now mandated to act under the Amendment Act. So an adult person or a functionary who believes or suspects on reasonable grounds that an act of domestic violence has been committed against a child, a person with a disability, or an older person must report such knowledge, belief, or suspicion as soon as possible to a social worker or South African police service official. Now, the difference in the reporting is that a functionary will prepare a formal report as per the forms listed in the alongside the regulations, where an adult person is able to go and provide their report within an affidavit to a social worker or a SAPS member for further investigation. Now, one of the things that a question that has come up is, well, what happens if I go and report, but upon further investigation, it is actually found to be untrue? What will then happen to me as an adult person or a functionary for that matter? Will I be held liable for false reporting? Well, no. That's the short answer, but basically the Act makes provision for if the belief or suspicion is made in good faith, so not under any malicious means, the person will not be held liable. So this means that they cannot be sued civilly, they won't face criminal prosecution, and cannot be disciplined within their workplace. So that is where we talk about the duty to report. And this is a protective measure. So what the amendments have tried to do is to look at those vulnerable groups where they may not have the means to report themselves, or they may experience this violence by the very person who is their primary caregiver. So it enables someone else to then report on their behalf. You can go to the next slide, please, Hananisha. So we now know what domestic violence is. We know what a domestic relationship is for those that experience violence and those that perpetrate violence. And we also know that there is a responsibility for functionaries and adult persons to report on behalf or report violence that they have seen, witnessed, or believe or suspect to be happening. But what do we actually do to apply for a protection order? Now, for those that don't know, a protection order is the legal mechanism that is put in place by the Act for someone to obtain protection from future acts of violence. But in looking at a protection order, I thought it would be great just to unpack a couple of the key concepts. So when we talk about protection orders, we will hear concepts like applicant, complainant, respondent, clerk of the court, and peace officer. Well, what do these mean? Well, an applicant refers to the person who approaches the court to apply for the protection order. Now, what we'll see is it's not always the person who's experiencing domestic violence that will go and apply for the protection order. It may be someone else who applies on their behalf. So that is the applicant. The complainant is the person who is experiencing the domestic violence themselves and is named in the application, and that is in the court, or it is the person opening a criminal case with the police. A respondent is the person who inflicts domestic violence on the abused person or uses a domestic violence act, and they may also be referred to as the accused if the matter moves from a civil to a criminal proceeding. The clerk of the court is the justice official responsible for the administration of the protection order, and this includes oversight over service and what we will learn about later, the safety monitoring notice. And finally, the peace officer. This is quite a blanket term, but it is a term used in the Criminal Procedures Act that includes any magistrate, justice, police official, or correctional official. Right, you can go to the next slide, please. So who can approach the court for a domestic violence protection order? The amendments make provision, and this is not all new, but it is further explained within the amendments that a domestic violence protection order application can be brought by any person who has been in a domestic relationship with someone who has subjected them to an act of domestic violence. So that is the person who's experiencing the domestic violence themselves. But it can also be brought by any other person on behalf of the abused person. And this could be by the functionaries that we spoke about earlier, or a concerned person who's interested in the abused person's well-being. This might be a family member, a friend, but a note here is when the application is brought on behalf of another adult person, that the complainant or the person experiencing the abuse must provide consent in the prescribed manner, which is one of the forms again that was spoken about in the regulations, that shows that they consent to the application being brought on their behalf. This is not the case in the only time this doesn't come into being is when the court deems someone to either is a minor or someone who is not able to make or provide consent, and this would be decided by the court. Also important to note, this was a provision set out in the Domestic Violence Act, but the amendments just further enforce that a child of any age can apply for a protection order without consent or assistance of a parent, guardian, or any other person. So that's just re-emphasizing that a child has agency to apply for a protection order on their own behalf. Next slide, please. So where can you apply for a protection order? So there are two methods. The one is traditionally through a magistrate's court, so that's in person, going to the magistrate's court, and you have to go to a magistrate's court that's either in the area where you yourself as the complainant or the person experiencing the violence resides, studies, this is a new provision, or carries on business or is employed, or where the abuser permanently or temporarily resides, studies, carries on business or is employed, or where the act of domestic violence occurred. Now that's important because it's also important to note that a protection order can only be applied for through a magistrate's court. You can approach a police station to open a case where a criminal case exists, but the protection order application itself is processed through a magistrate's court. Now, you can go over to the next slide, please, Hananisha. The Act also makes provision to apply for a protection order electronically. Now, I'm going to unpack that a little bit as we go through this flow chart. So here we see the process to apply for a domestic violence protection order. And we see what I'm calling in inverted commas, the traditional method of approaching your magistrate's court, being directed to the domestic violence court, completing your application, and with that application, an affidavit. And the affidavit is then forms part of that application that goes to the clerk of the court. Now that's your traditional way, and it's a way that will still be provided for through the amendment. But the Amendment Act makes provision for an electronic application. Now what does this mean? Well, an electronic application provides the opportunity for someone to complete their application either using a specific online portal that will be provided or hosted by the Department of Justice, or to email their application directly to the clerk of the court using a designated email address. Now, the electronic application still follows the same process as a paper-based application at a magistrate's court. It's just done online. It can be done in the complainant's home. It can be done through one of the functionaries. It can be done by civil society organizations like Mosaic, and it still has the application and the affidavit. Now, why I say it's a similar process is because that application will still go to the clerk of the court, and that clerk would be at the court that you name within your application. So the court that has jurisdiction over your matter. The clerk of the court would then prepare a file, or provide an application or a file number, make sure all the documents are together, and then submit that to the magistrate for consideration. Now, considering that, especially with electronic applications, the magistrate is not going to see the complainants. And in many cases, on that initial application, the magistrate considers the application on the merits that are contained within the application and the accompanying affidavit. Now, you'll see my little target mark there, and that target really draws attention to the affidavit needing to be as complete as possible. It needs to include all the information that pertains to the abuse experienced. What are the types of abuse? How often has it happened? Has the frequency increased? Has the seriousness increased? You're telling a story to convince the magistrate as to why an interim protection order is to be granted. So it's important that all that information is included. It's also important that the complainant or whoever is completing the affidavit with the complainant notes whether the respondent has access to a weapon. And the amendment now sees weapon as anything that could cause harm. It doesn't only speak to, before it was harmful weapon, which could be quite subjective. So it now speaks to any weapon. So all of that goes to the magistrate. The magistrate then considers, well, is this application, does this application, does it have enough prima facie evidence that the respondent is committing or has committed an act of domestic violence? And is the complainant suffering or will they suffer harm because of these domestic violence acts? And if the magistrate says yes, there is harm, there is domestic violence, and the complainant will suffer harm, they can then make the decision to issue an interim protection order. Now, an interim protection order, for those that don't know, is a temporary order that the court issues when and will provide the same level of protection as a final protection order, but is temporarily provided between the magistrate's decision and the return date, where the respondent and complainant come together to court to present their cases to the magistrate. In the instance where an interim protection order is not granted, then the magistrate will provide a notice to show cause. Now, this notice to show cause will be served on the respondent together with the protection order application, and that will inform the respondent that they need to return to court at a specified date to prove to the court why a final protection order should not be granted. At the same time, the complainant will also go to court to motivate why a final protection order needs to be granted. Now, the last thing I just want to speak about on this slide is you will see that right on top I put there an electronic repository. Now, this is a very exciting introduction through the amendments, is because it provides a centralized system for the storing of specific documents relating to protection order applications, and it will also assist the court to track existing orders as well as to identify counter and associated applications. Now, anyone that's worked within domestic violence and with domestic violence protection orders will note and will understand that often when a domestic violence protection order application is made by a complainant, there will be a counter application made by the respondent either at the same or another court. So you can go over to the next slide, Hananisha. So what the amendments now do is they now make provision for these applications. They make a provision for identifying and looking at existing and reciprocal orders or applications. So what the amendment now requires is, prior to issuing an interim protection order or a final order, the court must establish whether there is another order, either against the complainant or the respondent, that's previously issued by the court. So what happens in this case? So if there is a reciprocal application, so two applications that have been made, it now requires the court to deal with both applications together. Rather, what was previously happening and the gap that was experienced was that you would have application made in court A and an interim order or a final order is granted with specific conditions, a reciprocal order is then made in Court B, and there are then contradicting provisions made in that order, which doesn't help either the effecting or implementation of that order, or helps in the protection of the complaint. So where it is established that an existing order is in place, or that order needs to be recorded on file, and the court needs to ensure that no conditions actually contradict the existing orders. But where there is urgent relief required from an act of domestic violence, the court may issue a protection order that remains in force for a limited period while they then align the two orders. So this is a new provision, and one that really sets out to address that gap of existing and reciprocal applications. So you can go over, please, Hananisha. So in that process flow document that I flighted a little bit earlier, you would see that there was a red block that spoke about the domestic violence safety monitoring notice. Now, this is a completely new provision. It's not something that was spoken about in the Domestic Violence the Domestic Violence Act of 1998, and this was really brought in through an attempt of the amendments to prevent further acts of violence. And again, if you work in the domestic violence space, you will understand the danger that a domestic violence complainant is in after applying for a protection order. So there's often a period of time between the application and the serving of the order, and also then that time between the interim order being served and the final order, the return date to finalize the order. So this safety monitoring notice really aims to prevent further violence when a complainant and respondent share a residence. So important here, it's only when a residence is shared between the complainant and the respondent, because we know that not everyone is able to leave their home. So what it requires is it's an order of the court that requires SAPs, so the local SAP station, to check in either using electronic means, so by message, WhatsApp, SMSs, emails, as well as in person, to check in with the complainant to see that they are safe in their environment. And SAPS is required to provide reports to the court of what they have found during these visits and how many times they followed up. The notice itself is temporary. It will be in place for a predefined period of time, but it does provide for the SAPS member to, if they are not granted access to the complainant, to actually gain access by force where needed to ensure that the complainant is safe. So as you can see, it's very much a how do we prevent further violence and ensure the safety of the complainant. So who can apply for this? Well, the complainant or the person applying on behalf of the complainant can apply for this at the same time as applying for a protection order, or at the time of an interim order being granted, but before the court issues a final protection order. So really, and it can also, the complainant can also approach the court to apply for the protection order and for the safety monitoring notice anytime after the order and the final order have been granted. So this amendment really tries to provide further access to justice and prevention of violence to the complainant. So if you can just go to the next slide, please. So if we look at the service on the respondent, so for those that don't know, any notice or document that is issued by the court needs to be served on the respondent. Now, this applies to the interim protection order, the notice to show cause, as well as the safety monitoring notice. None of these come into effect unless they are served and there is proof that it has been served on the respondent. So what changes have we seen? What's new? So the Act makes provision for any of these documents to be served on the respondent either at their place of residence, business, employment, or study, and it can be done by either the clerk of the court, so it could be done in court, it could be done by the sheriff or a peace officer and SAPS official. The Act also allows for the documents to be served on any adult person at the address. However, if the complainant and respondent share a residence, service cannot be made on the complainant. And I think that's self-explanatory. There is also an option that if service is not able to be done in person, the court may order that this could be done electronically. And this will be further outlined in the regulations as well as the directives going forward. And then in terms of one more change in this respect around the service is that the Amendment Act does require service to not only be effected on the respondent, but also on the complainant. In some cases, you find that the complainant actually needs to go back to court to go and receive their copies, where the amendments now make it that service needs to be done on both the respondent and the complainant. All right, next slide, please, Hananisha. And you can actually go straight over. So if we talk about finalizing the protection order, let's look at what's new. So if you look at that process, the flow chart really shows how there's a return date where best case scenario, both the respondent and the complainants come to court, they stand before a magistrate, and the magistrate then makes a decision on whether to finalize the order. So some of the new provisions here is that if the complainant does not appear on the return date, the amendment now makes provision for the magistrate to extend the court date, which will also automatically extend the interim protection order date, as well as the clerk of the court has to notify the complainant and the respondent of the extension, and at the same time is able to check in on the complainants. And this provision was really put in place for complainants who were either kept from coming to court or were out of fear could not attend court. So this provides an option for a follow-up date without it just being struck off the court roll. If the complainant does not appear at the extended date, the matter can be discharged if there is no reason provided to the court. So here, if you do work with persons who are experiencing domestic violence, it's very important to emphasize that if anything stops them from returning on the return date, they need to inform the clerk of the court as to why they are not going to be there. And in some matters, the magistrate can then make a decision on the finalizing the order should the respondent not be there, and in exceptional cases if the complainant is not there. But ultimately, there needs to be a complainant in order to take a matter forward. All right, next slide, please. All right, very briefly, we're going to go through the enforcing the protection order. And if we look at the warrant of arrest, that's just the very next slide. It's important to note that the Act does make provision for the complainant to receive a warrant of arrest with the interim protection order after the respondent has been served. So remember, a signed warrant of arrest is active and it can't be effected if the respondent doesn't know that there is an order against them. and it is also issued with the final protection order. Now, some of the questions we often get asked is, well, when will SAPS actually use the warrants of arrest? Well, the amendments make provision for police to use the warrants of arrest of the respondent based on the following criteria. Where the breach is serious and there are risks to the complainant's safety, health, or well-being of the complainant or that of a related person. So that related person might be, as we spoke earlier, someone in the household with, and it might be the children, it might be anyone that's closely linked to the complainant. They also consider the length of time between when the breach occurred and reporting. So it may be that something happened 2 weeks ago and is now being reported. And SAPS may then decide not to use the warrant of arrest at that point, but will be required to issue a notice to appear in court for contravention of the protection order. And then the nature and extent of harm previously experienced. Now, it's important to note here that there has been a change in language that's been put forward by the amendments. And here we see the removal of the term imminent harm. And this was a confusing term where if you spoke to SAPS officials, imminent meant different things for different people. So when there was a determination being made on whether there was harm, it really could be quite subjective. So in an attempt to change that, the amendments now speak to still a determination, but it is SAPS has to determine whether there are reasonable grounds for arrest. And again, this will be outlined more extensively in the national instructions that SAPS will issue to its members. And one important note, just to re-emphasize, a warrant of arrest can only be used once. So if it is used by SAPS, it is for the complainant to go back to court to apply for a new warrant of arrest. All right, so next slide, please. So what happens if SAPS does not arrest the abuser at the scene? So if the police officer establishes that there are insufficient grounds for arresting the respondent, then they won't arrest the respondent. But this is what I was speaking to earlier. They have to give a handwritten notice to the respondent informing them that they must appear in court on a specified date for disobeying the protection order. Now, at this point, the complainant is still able to open a contravention of a protection order case, a criminal case with the police at their station. Right, and then just a few other new provisions to end off, and I'm sorry, I know I've been talking for quite a while, but hopefully you've found the content interesting and that has brought some new things forward. So as I said, there is a provision for an electronic repository, and this is something that is very forward-thinking of the amendments because it really allows a centralized system which eventually, as it progresses, will be able to be accessed by multiple stakeholders, to be able to have a system where you're able to track a protection order and the contraventions, if there are, and what the status is of that case as it moves forward. But that's something that will develop over time. For now, it's something that will be used for the clerk of the court to capture documents related to protection orders. And then one of the quite large focuses and a large proportion of the Amendment Act speaks to the court orders to information from electronic communication providers. Now we know we live in a digital age, and domestic violence takes so many forms. It is no longer just intrapersonal or interpersonal. It can also, interpersonal has extended to digital means. So electronic communication service providers can now be ordered by the court to provide information to the court that could include electronic communication identity numbers, as well as identifying and contact details for who those identity numbers are assigned. So if we think about something like RECA, when we RECA a SIM card, that gets all our information gets stored by the electronic communication service provider, and the court can order for that information. The information provided for in the amendments are aligned to the Electronic Communications Act of 2005. And this is really for where there is an act of domestic violence performed making use of an electronic communication service. The communication service provider is then able to provide that evidence to the court. So this might be persistent messaging, messaging of explicit content, sharing of explicit content, sharing private content outside of the relationship, or used as a form of domestic violence, or persistent phone calls, anything like that. Can constitute domestic violence under the Act, as long as it happens within those domestic relationships, as we spoke about. The court can also order for the electronic communication service provider to remove content where it has the power to do so. So that really brings me to the end of my portion of the presentation. I hope that it has sparked some thoughts around the Act, the amendments, what it means for practitioners, for first responders in taking this forward, and what it means for ensuring increased access to justice and safety for those experiencing domestic violence. So I'm going to end off now. I want to thank you all for your time and for listening so attentively. And I welcome any questions, and I also invite anyone on the panel to share in answering some questions and taking some comments. Thank you so much.
Thank you. This is Hanunisha here again. Thank you, Karen, for the presentation. We do have one question from the chat. The question is, who would be considered as an older person? Karen, we can't hear you.
So sorry, I was on mute. I'm actually just getting the Older Persons Act up. I'm showing a gap in my own knowledge here. So an older person, according to the Older Persons Act, means a person who, in the case of a male, is 65 years of age or older, and in the case of a female, is 60 years of age or older. I think it goes pretty much alongside the age of retirement, or the perceived age of retirement in the country. Am I still audible?
I thank you. Thanks, Karen. We heard you. I was on mute and speaking. Anybody can raise their hands for a question. I see there's one hand up. Mulja, you can go ahead.
The presentation. I have two questions. The first one is how long is a protection order valid? Because previously it was ever until it was varied ever. And the second question is the application process for a warrant of arrest? Let's say I've already been granted a protection order. So do I restart the whole process? Do I go to court and say, I just need you new warrant of arrest to be issued? Because in the previous instances, protection was valid forever. So I would go if I had the protection order was used, I would then go to court and have a new warrant of arrest issued. Could you explain to us what is that process?
Sure, thank you so much for the question. So you're quite right. A protection order, a final protection order, is there is no expiry. A final protection order is valid until, or if in the case a person approaches the court for a variation, which still remains part of the same protection order, or applies for the protection order to be withdrawn. But no, the final protection order remains in place. It does not expire, and that is the same with any warrants of arrest that is issued with the protection order. So if you have a protection order for 10 years and you have not used the warrants of arrest, the warrants of arrest is still valid. If you go to apply for a warrant of arrest from the court, you should be able to apply for only the warrant of arrest. You do not need to go and apply for, start the entire process again, because your protection order remains in place. So if you use the warrant, it doesn't affect the protection order. It's only the warrant of arrest that is used. So you can approach the court just to get a new warrant of arrest. Just a note on that, the protection order, so when we're talking about an interim protection order, the key there is interim. So it is only an order that provides interim protection or protection between the time of the magistrate making the decision and appearing in court on the return date to finalize the order. So that is the order that is time bound. But the final protection order remains in place until a change is requested at the court. I hope that answers your question.
Are you covered? You said you had a second question. You want to go ahead with that?
No, thank you very much. She's answered both my questions. I really appreciate that. Thank you.
Okay, thank you. Then before we take another hand, there is a question on the chat. It asks, is it mandatory? This is Jeanette asking, is it mandatory for the clerk of the court to assist victims in completing the application form?
Thank you so much. The amendment does make provision for the clerk of the court to assist the applicants if they are unable to complete the application themselves. It does also make provision for assistance for those that are unable to write or read or require translation services. Provision for that. In the presentation, I spoke more to new provisions. So those were provisions that were made in the Domestic Violence Act, the principal legislation itself, but it has again been re-emphasized in the amendments.
Okay, thank you. We can take a hand, Faith. Do you still have a question?
Thank you very much, Karen, for the informative presentation. I just wanted to find out, with regards to the renewal of the warrant of arrest, is there a limit to the times that you can apply for the renewal?
Thank you so much for that question. I hope you don't mind. I'm just going to leave my camera off. I'm experiencing a few connection issues. So there should not be any limits to the number of times that you can go and apply for a new warrant. The warrant of the arrest is really provided so that if there is a contravention of the protection order, that SAPS is able to arrest immediately. That's the purpose of it. So if the warrant is being used by SAPS, then there is no reason why you aren't able to go and apply for another one. Of course, when you go to apply for a warrant, it is issued by the magistrate. So it would be dependent on them issuing that warrant.
Thank you very much.
Thanks, Karen. Karen, I see there's a number of questions on or requests in the chat for the presentation. I just want to confirm, will the presentation be made available to people? Some people also saying that they might have struggled to hear some times.
Oh, I apologize if my sound was disappearing at all. I did say at the beginning that I will provide a PDF version of the presentation to the Secretariat for sharing, and hopefully the recording would also be made available either via a YouTube channel or something similar.
Thanks, Karen. So everyone, I hope you heard that it will be made available. The presentation that was presented by Karen, the information in there will be made available for everyone. Nkobo, you can go ahead. You're still muted if you wanted to speak. Okay, maybe we'll come back to you. Rosie, you can go ahead.
Hi, Karen. Thank you so much for your presentation. Karen, just one thing. What is actually meant by a state-to-pay facility in terms of service of domestic violence documents? And is it really necessary that a court should make use of this facility if the police are actually doing the service of these documents?
Thank you so much for that question. So if I, just to understand you correctly, your question is first, what is meant by state to pay for service? And the second is around, is it necessary for that system to be in place if SAPS is doing the service? Is that correct?
That's correct, Karen. The reason for me asking is that one of our courts were actually questioned by a public protector concerning a state to pay a facility, and the community wanted to know why are they using the police when this facility is much more beneficial to the less fortunate people to have their documents served. So that is actually why I'm requesting, because I assume that the police are much more effective in that they do not charge, and if it would actually be less costly on the state itself when the police are able to do this duty for us.
So I do hear what you're saying. So the Act does make provision for the state to pay the fees for any service in terms of if it is assessed that the complainant or respondent does not have the means to pay fees, and that would obviously be making use of the sheriff. I would invite anyone who is on the call that also works within the courts and makes use of the sheriff to also share any information that they have on that. The question around why should it be used if police could serve, I think that really comes down to the courts itself. If it is something that requires immediate service for an urgent matter, and please, this is my own thinking, then it would be, and the police are only obligated to serve within a specific period of time, but a sheriff is able to do that before, it then is in the best interest of the complainant to have it served by the sheriff, if it's something that can be done very quickly. But it is something that I would love to invite other justice colleagues to chat about, well, what must happen in that instance where someone is questioned about the use of the sheriff when the Act makes provision for it. Sorry that I can't offer a more comprehensive response there.
Thank you, Karen. That actually did help me a bit.
Great.
Thank you, Karen. Then there's a comment from Izette saying that the Act or the provisions of the Act should really be available to all vulnerable women. I am accepting that this is with referral to mandatory reporting, where it was a certain group of people and not all women, or in all cases where there is an obligation for mandatory reporting by others than the person experiencing the domestic violence. I think, Karen, you did speak about this, and that there was this debate amongst the various entities and organizations when the Act and the amendments were considered about the agency of women in general, and whether there should be a mandatory reporting in respect of everyone. But anyone, can give some comment on what Izette has mentioned.
So it's a really great question, and I think one that came up again when in the webinars last week around the regulations. It was also brought up about women being seen as a vulnerable group, and we don't look at it and say, no, they're not a vulnerable group, but at the same time, where does the agency lie? So if someone is experiencing domestic violence and they know that if they tell someone, that person has to report it, but they're not in the situation where they feel ready to report their domestic violence, it could reduce help-seeking behavior. So they could then not speak out. But at the same time, persons may fear criminal prosecution and may not make themselves available to receive those complaints. So it's a very contentious issue, and it was a very contentious provision that was in the draft bill, or the bill at the start of public consultations. There was quite a strong consensus from civil society and other groups around the mandatory reporting of all acts of domestic violence. But we take on board what you've said, and I suppose it's also about, well, how do we as civil society and government organizations and faith and traditional faith-based and traditional organizations, how do we come together and make sure that we're working collaboratively enough at a very local level to provide almost a safety net of some kind where everybody understands the law, everybody understands what is available, what services and what legal remedies are available for those experiencing domestic violence, so that there is that protective measure built in to those local coordinating platforms, I suppose, if we want to use a particular word. But I think so. I think there really needs to be a broadening of, yes, we have the law, but how do we make sure that we make a conducive environment at a local level where first responders are seen as people who are there to assist and provide accurate information, where we create a society of care, I suppose, that somebody is wanting to come forward and report rather than wagging a fear of criminal prosecution if I don't report. So I think it's about almost looking at it a little bit differently. But for now, the Act does make provision for mandatory reporting for those who may not otherwise be able to report.
Thank you, Karen. And then there was a hand. Nomshle had a hand up. I'm not sure it's not there anymore. Not sure if you gave up, but I was going to recognize you now. I see you back, you can go ahead. Nomshle, you're able
Morning
to
all. Hi, can you hear me?
Yes,
Morning.
now we can hear you.
Yes. Karen, I've got a question here. I had a client that was issued an interim protection order and a warrant of arrest, but in 10 years back, and then her daughter is doing the same thing. And when she goes to the SAP, they say it's old. So I just want to know, how long does it supposed to be with how long does we have to keep it when they say it's old after 10 years old? I don't know whether you get my question, Karen. Hello. Is it
Order back for. No, is that correct?
Hello.
My signal is not becoming a little bit weak. But no, Claire, the short answer is the protection order does not expire.
Mm-hmm.
So even after 10 years, it is still in place.
And Nomshle, you covered? I'm not hearing anything.
Hello, now I can hear you guys.
Were you able to hear Karen?
No, I didn't hear Karen. I don't know if there's a...
Apologies, my connection seems
now I
to
can
be
hear you.
dropping.
Yeah, there's some interference. I'm not sure.
Reinstate quickly. If any of the other justice colleagues are able to take any of the questions, please go ahead.
Yes, so if I may repeat, Karen indicated that it does not expire and you should be able to still use it if it was contravened. Normally you covered?
So it does not expire. Even if it's 20 years time, you can still use it.
Yes.
Okay. Okay, so the SLP, they've got a problem with that. Okay, I'll just need to explain to them. Thank
Yes.
you.
Okay, I can just link this. There's a question on the chat from Margaret, and it says that it seems in her area the courts have a 5-year period for the protection order.
Okay.
She says our court makes the final protection order only for 5 years and then it expires according to them. But the question is, why do you think that they do that? But so it seems to be a particular problem in that area, but it should not be. As Karen has indicated, it should be valid. It should remain valid for as long as the person requires the protection. If I understood you correct, Karen, anyone from Red, maybe you can indicate what area you are in so that we can sort of look at why would that be happening in that area?
Okay, I'm here in Philippines.
Hello, yes, I'm from Bethlehem area, Free State.
Okay.
Okay, so if I can just understand it correctly, so Maret from Bethlehem say that the courts make it for 5 years, and it seems thereafter applicants must apply again. Normally, you are saying in Philippines, they link it to a specific period, or it's just why did they say your client cannot enforce it? Was it the 10-year period?
No, it's not the court, it's the SAP, it's not the DOJ. When the client went to the SAPs, they tell the client that it's invalid, it's not working anymore. So I just wanted to clarify that.
Okay, thanks, Mamplesho. Yes, no, they should not be telling the client that. There are colleagues of DOJ on the chat here, and then we can look into in Pillar 3, maybe we can look into what is happening in Bethlehem. Why would they be making protection orders for 5 years and requiring applicants or survivors of domestic violence to go to court again? I see there was another hand from Zuleka. Zuleka, that was the last hand that I see on my side. Go ahead, please. Zuleka, you're still on mute if you are talking.
Can you hear me?
Now I hear someone. Is that Zuleka? You back on mute again?
Can you hear me?
Yes, we hear you. No, back on mute again. Sorry, we just hear you when you say, "Can you hear me?" There you are. So, now, perhaps you can put your question in the. There, you are unmuted. No, I don't know. Maybe you're struggling with your mute button. Perhaps just pop the question. Yes, go ahead, Zuleka.
Question in the chat.
Okay, we heard you. You put your question in the chat.
Yeah, if maybe I'm having problems in terms of hearing my question, but it's a concern regarding the no arrest of the abuser at the scene because of insufficient maybe information for the police to arrest the respondent. In your slide, there was something that I missed out, like something that's supposed to be a written thing. That information, I'm not clear about it, and for me it's a concern because some of our clients abusers are not arrested in the scene.
So I'm missing that point that, okay, due to the insufficient information or evidence, so the abuser won't be arrested by the police. And the next step will be the written, there is something that she has to get a written thing. I didn't get that.
Yeah. Thank you so much for the question, Zuleka. So you're quite right that there is an instance where if the police official doesn't see sufficient grounds or reasonable grounds to make an arrest, they don't have to make an arrest.
Yes.
We don't know. We haven't seen the national instructions as yet. So the legislation or the amendments make provision for the national instructions to be done within a certain time frame. So we haven't seen the national instructions yet as to what those particular grounds will be and how that will be operationalized. So we wait for that. But in the meantime, to answer your question, if someone is not arrested, it doesn't mean they haven't contravened the protection order. So they have still gone against what the protection order says. And so police hand notice, and it will be on a prescribed listed in the regulations, and that handwritten notice instructs or tells the respondent or the person who's used the violence that they would need to appear in court on a specific date. And they appear in court because of their contravention of the protection order. So when they come to court, they will need to then appear before a magistrate to say this is the contravention, and then the court process would then would then continue. So it's not that because there was no arrest that there isn't a follow-up court process. It's just merely that police did not find sufficient grounds to use the warrant of arrest to remove the respondent at that time into police custody. But they will still need to appear in court, and that's the handwritten notice. I hope that clarifies it a little bit.
Yes. I think it's giving me more clarity, you see, so that I can even assist my client, you see, if maybe there's not enough evidence, what further steps that we should follow, you see, so that at least she can be updated, can also be updated in terms of follow-up in court. Thank you very much.
Great. And then Zuleka, just to add that this is not a new provision. The handwritten notice is something that has been part of the Domestic Violence Act of 1998. And if I'm not mistaken, it's Form 11 that needs to be provided by a SAPS member at the when.
Yes, I understand. It's not something new, but sometimes you will find out these issues or aspects are documented in some of the acts, but because you are not clear about that, and then you just maybe not follow the proper procedures. Now that you have explained, I've gotten an understanding, because sometimes we don't assist the client, like you follow up with the client after maybe the abuser was not arrested. We leave the client alone to do her follow-up with the court, you see. So it also helped me to speed up, you see, to follow up with my client, what are the outcomes and all this stuff. That is my main concern.
Great, thanks, Zuleka, and thanks for the work that you do.
Thanks, Zuleika. The hands of Nkobo and Rosie, are those legacy hands or do you have new questions?
Hi, Hannah. I do actually have a new question for Karen.
Okay, go ahead.
Karen, just one of the aspects that you brought up was about a child of any age can now apply without the help of a guardian. Okay, will this apply in the vice versa way where a complainant can open a domestic violence on any child of any age, or is it still is there a cutoff age where a complainant can apply for domestic violence against a child?
Thank you for your question, Rosie. So just to understand, is your question whether a complainant is able to approach a court to apply for a protection order against their own child of any age?
That's correct.
I'm not 100% sure. Actually, that's a great question. I'm not sure if anyone on the call has an answer to that. I'm happy to find out and feedback, but I'm actually not 100% certain. So I don't want to share information if I'm not 100% clear. I don't know if there's anybody else that could assist. But Rosie, that's a great question. Thank you.
Thanks, Karen.
Okay, there are other colleagues of Pillar 3 in the chat, but as far as the Act and the law pertains that you can open or you can make an application where the other party is that is the perpetrator is a minor. Or your own child. That is my understanding of the question. Advocate Kambula, the question was, where your child is the perpetrator, can you make an application against your child for protection?
Regardless of their age?
Yes, regardless of their age, meaning where they are actually minors.
Thank you. Thank you, Aronisha. Yes, you can. You can actually do that. But then, in terms of the Child Justice Act, the criminal responsibility has been increased from 10 to 12 years. So what it means is that if your child is of the age of 12, you can actually apply for a protection order against that child who has perpetrated an act of domestic violence against you. Thank you. And I would also like to say that we are actually experiencing a lot of children who are perpetrating gender-based violence and femicide in our country, and the numbers are increasing. In 2020, 2021, we had an increase of 22% of children who have perpetrated sexual violence against other children and also against adults. So this is one thing that we really as activists, against GBV to look into, because now in South Africa the age of the perpetrator of GBV is getting younger and younger day by day, and the Department of Justice is collecting statistics of children who are perpetrating violence from the age of 10. And it is quite sad that we have a 10-year-old who is actually perpetrating rape, and rape is the most serious sexual offense. So there's a problem in South Africa that we really, really need to do something against. Thank you so much.
Thank you, Advocate Kambule. Novo, is that a new hand or is it a legacy hand in Zuleika? You are muted if you are speaking. Okay, your hand is still up, and you are still muted if you are speaking. Okay. Then there's just a few comments on the chat. Again, that I just want to highlight. Is that indicate that she just wants to highlight that a challenge that that clerks of courts might experience. The regulations propose a 2-hour return 2-hour return space in which the clerk must respond to the complainant, and she's just highlighting whether that this might be difficult to attain and maintain by clerks. They might not be available to respond or attend to the matter within the 2 hours. Izet, I just want to mention that we do have a session this afternoon at 2 that specifically focuses on the clerks of the court, and I will actually raise this if you are not available at 2 with them again, just to see how, you know, this to highlight it and how we can address it to make sure that the 2 hours will be attained and maintained. Izet also raises that the regulation says that when the notice, when a copy of the notice is to be served, that it can be served without annexures, and she indicates that it should really be served with annexures, and it could be problematic to serve it without annexures. Would it be proper service, would be the question, I suppose. Yes.
So I think just in terms of that, it was put in the draft regulations that went out for public consultation. So hopefully through that process, a lot of these questions would be also addressed and answered. And what is fantastic about a public consultation process is that it's not only civil society organizations that get to input, but also government departments themselves. So as I noted, there were 2 webinars last week that spoke to the regulations, and the closing date for submissions was on the 11th, so on Monday. So hopefully a lot of that was brought up, and the department is now able to look at that to see, well, what is feasible, what isn't, and how would it play out in the operationalization. But really, really valid questions. Yeah, it's great to hear so many people having engaged in depth with the regulations as well as the amendments.
Thank you. There is a question, Melissa. I see that you have a question. I hope that you've noticed that Advocate Kambula has responded on the chat to your question. If you are answered, just let me know with a wave or a thumbs up. Otherwise, we can take your question, and then that closes the questions. If no, let's try you again. Do you have a new question, or is it an old hand? Are you able to speak? Okay, there seems to be nothing. Maybe it's an old hand. If you are struggling, you can just drop your question maybe in the chat, and we can then get back to you. And then if there are no further questions, I want to thank Karen for taking out the time to explain the amendments to us in a simplified manner. Thank you for the information provided in the presentation. It made it simple for us to follow and to understand what we can be looking for in the amendments. I also want to remind participants here that Pillar 3 is bringing these webinars, and it is to impart information about the amendments to the Domestic Violence Act, but also the other 2 acts that have been amended as part of our intervention to address gender-based violence and femicide. And so there's going to be a number of these webinars, and I ask you to look out for the webinars. When you have attended a webinar, please share with your friends and your colleagues that they attend the other webinars. As I've mentioned, this afternoon we'll be having one with the clerks that will will deal with the clerks of the courts that will deal with their responsibilities. It's aimed at the clerks of the court so that they also know what is expected of them in terms of the new act, and specifically the Domestic Violence Act. There's the last question on the chat. If I can just read it for everyone. Do we have an indication when the Amendment Act will come into operation? Because I'm sure many people might have been thinking about this. And then the comment there from Advocate Kambula is the date of commencement will be announced by the President soon. So it will be looking to finalize all the regulations that we have or that we need to implement, so that those are finalized and in place when it is the commencement date is announced. So thank you everyone for attending. We look forward to engaging with you more going forward, and please do engage on the X. Do engage in terms of mentioning what we still need to do, because this is not the end. You know, we've started a process, we've implemented through 3 new acts, but this is not the end in addressing gender-based violence, and this is not the end of the NSP. So all your comments are taken on board in the Pillar 3 group, and we are working on, continuously working on and looking at where improvements need to be made. So thank you everyone, have a good day.
Ananisha,
Yes.
I would like us to inform all the delegates that we have another webinar scheduled for 2 o'clock this afternoon, which will be zooming into the applications for the protection orders by and the role of the clerks of the court and other disciplines that are responsible for such. So we are inviting you to attend. Thank you so much. It's for today.
Thank you. Thank you, Advocate Kambule. As we've mentioned, 2 o'clock today for that webinar, where the clerks of the court, where we are focusing on the clerks of the court in terms of their role in implementing the Domestic Violence Amendment Act. Let me just see, there's still a hand. Okay, it's still the 2 hands. Thank you. We see you in other webinars.
Thank you, colleagues. It was a good presentation. Thank you so much.
Thanks, everyone. Have a great day.
Thank you. Bye.
Puti, coma le nto yakho. Xa Puti, xa kephumile kaloku uzawungena emva kwakhe ne. Okay, wenza ntoni cousin? Cousin uyathukisa thembisa kodwa usuka ekhaya. 15 ama-21. Iphi endaweni 15 na-21 kalanga? Ubona ungambhala ngoku lethu. Nintoni ingxabano yakho no-cousin wakho? Ntoni ingxaki yakho no-cousin wakho? Come clean. Come clean. Baninzi endlini awuzothukwa wedwa umkhazini wakho. Usithuka endlini, ukuthuka special alikhothe ekhaya. Uthukela ntoni? Uthukela xa ngenxa lezinto ezenzayo. Wenza ntoni? Uthukisa, uthuka abantu emva kwemizi ethengiswa ngabakwazi ukuthi athengisonke. Uthuka abantu. Uthengisa ntoni? Uthengisa. Uthuka abantu baphezulu. Bathiswa hayi yeke lenzayo. Yabanga. Yabanga. Antoni. Nisazi bani sikolo? Nisazi. 10. Yakubeka thuba Jesu. No, akuthukisa qha. Akakuphusha kakhulu. So, there's it. I don't forget to calculate it. You forget to calculate it. Can you handle for if you don't I find up? From handle telephone job. I change it because then isn't the most value happen. Baby, yeah. General someone up. Things are right about what is right like that. Family house, no? Mama, cousin, okay, Lavana. Cousin, Kalangabon cousin, okay. So the city la khale ko ne ko be renda samu so uthi uthi lo renda so tinga renda zama ka khala so ka phezu era so lensenza ngalo mama ingani so okay mana ngibona sana kaloku ubhalile into amfakazi nandibhale wrong apha I'm supposed to go there. Okay. Sibhala phangelo. Waligama kwavathi seneminyaka uzalwe nini i-address yakhe. Phone yakhe. Ngibale Google. Zalwe 1918 lo 1820 Nkazana sazana ngathi sikhula ngomntana nengaphakathi selicho nkazana akuhlumuza nangana nkazana ngayo bathi I'm reflecting on how many years experience. Speaking from me, the only another month again. I would say 6 months. Then 6 months. Postpone. Noticias.
Thank you.